Webb.
Mr. McAnally, good morning.
Thank you, my Lord. Good morning, my Lords, my Lady. I, of course, appear for the appellant, Mr. Webb. In terms of this formidable array to my right, it is led by my learned friend, Mr. Hikaka, who is at my far right, and Mr. Mullins, closest to me. And behind them are my learned friends, Mr. Marshall and Ms. Clues.
Thank you.
So the matter, my Lords, is essentially, my Lady, is essentially, well, at its heart, is a matrimonial case, but it raises some difficult issues which have occupied the High Court, of course, and the Court of Appeal. And the most difficult of those issues can be grouped under two heads. One is what I'll call the debt issue, and that raises issues in terms of what is a debt or qualifying debt for the purposes of Section 25B of the Matrimonial Property Act, which I'll soon take the board to, and of course the laws around trusts. And there are points made there in terms of sham, perhaps what might be called objective sham, which is a very novel matter, I might suggest, and we'll need to come to that in due course. The matters might be described as somewhat technical, but they go beyond that, and we are looking at an important question of statutory interpretation as far as the debt question is concerned, and it does raise a very interesting and difficult question around the interrelationship between perhaps New Zealand and the Cook Islands, and how that debt, which otherwise would qualify for the purpose of Section 25B, I don't think that's an issue, how that interrelationship affects that. Mrs. Webb's position, of course, is that because it is a tax debt or a tax liability, it is unenforceable in the Cook Islands and therefore does not need to be taken into account for the purposes of Section 25B.
Mr. McAnally, can you speak up a little bit? We can hear you, but it's possible people at the back of the court can't.
Thank you. I will, my Lord.
Thank you.
So I'm going to start with the debt matter, and the reason I'm going to do so is not because I couldn't start with the trust matter. It is because, as far as the debt is concerned, it really is all or nothing. If the board's advice to Her Majesty ultimately is that the debt does qualify for the purpose of Section 25B, then any matrimonial property pool is exhausted, and that is common ground, and the validity or otherwise of the trusts doesn't matter. With the trusts, there are certain permutations. There are two trusts in issue. The outcome and the board's advice might be different depending on whether one or other, or of course neither, of the trusts are valid, and if it is one but not the other, which one? And that will raise side issues. They're difficult issues, but they are side issues in terms of Section 44 of the Matrimonial Property Act, and there is a valuation question there as well, which I'll touch on before I finish up this afternoon. In terms of some housekeeping matters, the page numbers of the physical documents and the electronic bundle are the same, so I'll only be using one page number, and that is common to both. And there is an agreed timetable in terms of speeches that my Lords and my Lady are probably aware of, and I will be finishing up by 3 o'clock at the latest this afternoon to let my learned friend start. So the debt, and my Lords and my Lady have probably had an opportunity to have a look, even if a quick one, at Section 25 of the Matrimonial Property Act. The Matrimonial Property Act of 1991-92 in the Cook Islands was adopted by the Cook Islands from the Matrimonial Property Act of New Zealand of 1976. And that New Zealand Act, with some relatively modest modifications, was carried over to the Cook Islands. And so when I refer to the Matrimonial Property Act, it's the Cook Islands legislation, obviously, because this is a Cook Islands case, but we are talking about New Zealand legislation in terms of its genesis. The section that we are concerned with, if your Lordships and my Lady wish to go to it, is in the primary bundle of authorities. It's page 1014. It's behind tab D of the hard copy.
I don't seem to have a bundle of authorities. I'm not sure why.
Mine's
Mr. McAnally, my page 101
Oh, there it is. Okay, sorry, I missed it. Right.
appears to be section 66 of the Cook Islands Constitution Act.
You said behind tab D in volume 1. I've found the Act behind tab M in volume 1.
There may be an explanation for this confusion, my Lords and my Lady. There is a primary bundle of authorities which comprises one volume only.
Oh,
That's what I've got, I think, which is...
oh, right.
It
I
is
have
tab D.
a deeper problem, which is that the memory stick is not complying with your suggestion that the pagination is the same. I think my pagination is about 11 apart.
In terms of the page numbers at the bottom right, my Lord,
That may work, but it's not the electronic pagination. Yes, 1014 is my 1025. Now, it may be that a later memory... There was a problem with the memory sticks, I believe, last week, with the result that they arrived late. And then I'm going to just check whether this later one here is differently numbered. Anyway, I'm on your page.
We've got the Act.
I'm sorry, I'm having trouble because my 1014 corresponds to page 1002 or 3 in the bundle.
Yes.
which is different to my Lord Briggs' page numbering.
No, we're in the
That's-
same boat,
So there is a common...
same electronic boat.
Yeah.
I'm just looking to see whether it changed in a possibly later memory stick.
We're looking for the matrimonial property thing. I've got it separate. It's 1015 in my thing.
We've all got the page, haven't we?
Yeah, I'm on the page.
David, you've got the page?
I've got the page.
Well, irrespective of unfortunate numbering, we've all got the page. So let's proceed.
I'll try to get to the bottom of that at the lunch
If
hour.
there's any consolation, you're not the first person who's found...
Well, that is some comfort, my Lord, but it's not entirely satisfactory. The only thing I can suspect has happened is I wonder if the addition of the index at the front of the bundle has thrown the page numbering out, but that should only be by one page.
Well, all I can say is if you add 11 to get to the electronic, it'll work, or I can add 11.
Thank you, my Lord. I
But
can't.
that seems
Who's
to be the
going to add
disparity.
11? Will you add 11?
I will.
Or do you want us to add
No,
11?
let me do that.
Okay.
Thank you.
And I'll make a note so that I do remember. And it'll be an ongoing test of my my arithmetic throughout the hearing, but that shouldn't be too difficult.
Okay. Yes?
So, page 1014, 1025
Yes.
of the electronic bundle.
Well, I'm working from a different bundle. So can you give me the section? Section 20?
Section 20.
Very well. 5.
Section 20. What we're ultimately concerned with is section 25B.
Yes.
It's a convoluted section, somewhat unhappily drafted, and of course has been repealed and replaced with new legislation in New Zealand in 2001, but the Cook Islands still persevere with it. There is a process of reverse engineering whereby one ascertains whether a debt is a personal debt it is common ground in this case that it is. And for the purpose of section 25, there is a question as to whether or not it is secured or unsecured. If it's secured, section 25A is likely to apply. I don't understand it to be seriously argued that this debt is other than unsecured.
Well, I think the point is still being taken about the caveat and so forth. But for the time being, let's assume it's unsecured.
That matter has been addressed in both the High Court judgment and the Court of Appeal judgment. I do touch on it briefly in Mr. Webb's written case.
Let's assume for the moment, until Mr. Hikaka persuades us otherwise, that it's unsecured.
Now, it's an interesting section, and it might be argued that it potentially lends itself to unfair results, but if it does, that is the legislative intent. As section 20, the introductory part, section 20, subsection 1 of the section makes clear, the purpose of it is to ensure that the position of creditors of one or other of the spouses is not compromised. And the New Zealand case law on the section confirms that, and the Court of Appeal, of course, recognised that in its judgment in this particular case. In short, a creditor is entitled and able to deal with its debtor as if the legislation had not been passed. So whilst it is perhaps easy to say the legislation is for the benefit of the spouse in question, the debtor, it's not as simple as that. Whilst the case law and the legislation make it clear that the assets in question, and I'll come to that particular matter, are to be available for creditors, and that is to an extent to the benefit of the debtor, because he, and I'll use the he in this case because we're talking about Mr. Webb ultimately, he is able to have recourse to the assets in question to satisfy the debt. But more importantly, the advantage is for, or the main benefit is for the creditor. And this case perhaps illustrates the point, and in many respects, I submit that the question of enforceability as a matter of private international law in the Cook Islands is something of a red herring. Obviously, the point has to be dealt with. If the board is not with me to the point where I say that enforceability doesn't matter, I need to deal with it, and I will. But ultimately, the important point is that the assets in question should be available to the debtor or the spouse in question to pay his creditors. And to illustrate, it may well be the case, if we use the present as a useful starting point, that ultimately there could be enforcement problems if the Commissioner of Inland Revenue in New Zealand was trying to enforce against particular assets in the Cook Islands. Ultimately, I will say no, there isn't, and we'll come to that. But if we assume for the moment that there could be a problem, in my submission, that doesn't answer the point. Mr. Webb could sell assets, whether they're in New Zealand or in the Cook Islands. He could mortgage them and borrow against them, all in order to satisfy his debt or his debts, as the case might be. And that has nothing to do with the question of enforceability by the Commissioner of Inland Revenue as a third-party creditor vis-à-vis the Cook Islands.
You're coming on to it. We've seen the judgment entered against your client in the autumn of 2018, and we were wondering what steps the Inland Revenue has taken in the course of the last 15 months to enforce its judgment.
I can help a little, my lord. I don't want to try and help too much because there is no evidence. There are proceedings in New Zealand, and my scant knowledge of those proceedings, I'm not acting on them, is that the Commissioner is applying for the appointment of receivers of Mr Webb's assets in both New Zealand and the Cook Islands. And that is all I know, and that's as far as I can take that particular matter, my Lord.
Sorry, can I say that again?
The Commissioner of Inland Revenue in New Zealand has brought proceedings in the High Court of New Zealand for the appointment of receivers in respect of Mr Webb's assets in both New Zealand and the Cook Islands.
They haven't been appointed yet?
No, I don't believe so, my Lord, no.
When we read the judgment of the 26th November 2018, which of course postdates the Court of Appeal here, we noted that there was going to be no enforcement of that judgment pending a judicial review that your client had launched. Has that been resolved?
I can't say, my Lord, I don't know.
Very well.
I would really only be speculating. I'm really not sure.
May I ask, your client is resident in New Zealand, is that
That's right, my Lord, yes.
Yes, now, I mean, you asked us to look at we've all found section 20 with a degree of difficulty.
Yes.
Which bits do you want us to look at?
Well, subsection 1 is important, but I've traversed that, and the important point I extract from subsection 1 is the policy behind the section, which is creditor protection. And to extrapolate that a little, when the Matrimonial Property Act of 1976 was passed in New Zealand, it was quite, in that day and age, quite radical social legislation in that before that time, the rights of a non-owning spouse, and in reality we're talking predominantly the wives, particularly in that time, had little to no rights in terms of matrimonial property. So what the 1976 legislation did was introduce a quite radical regime whereby the family home and family chattels were shared, and there was a presumption that other matrimonial property would be shared equally as well. But there was a trade-off, and Section 20, I submit, was that trade-off. Creditors weren't to be out of pocket, so to speak, as a result of the social development. So Section 21 is important. It is dealt with in the case of Wilson and Wilson, which is in the secondary bundle. I'm not going to take the board to it. And Section 25B, obviously. So
you skipped over Section 22. We did notice that each spouse was to have a protected interest in the home, and not all the other spouse's debts could be set against it. But for some reason, that doesn't apply.
It hasn't been raised in this case, my Lord.
Very well.
And that is a question for Mrs. Webb, but it might be that the protected interest, of course, is only $10,000, which in 1976 might have been worth something. It isn't worth a great deal.
That figure has not been enlarged?
Not in the Cook Islands, my Lord, no.
Oh, well, then it's de minimis. Very well.
It was enlarged in New Zealand, and it may have creeped up, if I recall correctly, to something around $58,000. And to give some idea of context in terms of today's exchange rates, if one halves a New Zealand dollar amount, one roughly gets the equivalent pound.
Very well.
So Section 22, my Lord, no, it has no application. It could, it doesn't, on the facts of this case. So we are concerned with Section 27 might have been relevant if whether the debt was personal or matrimonial was an issue. It's not. So we come down to Section 25B. And the easy part of that, from my point of view, is that subject to that side issue, and I mean no respect by calling it that, around secured or unsecured, there's no other real dispute that the section would apply in this case, subject to the enforceability issue.
When I read it, I think I must have misread Section 25, Mr. McAnally, because it seemed to me, reading it first of all, that you've got to deduct from the value of the matrimonial property owned by each spouse. So let's assume for this purpose that that your client does, rather than the trusts, own this relevant property. From the matrimonial property owned by each spouse, you deduct his unsecured personal debts. So reading it at first blush, I thought, well, however big the tax debt is, if it's relevant, it certainly eliminates your half, as it were, but why does it eliminate the wife's? But that's a misreading, isn't it, Mr. McAnally?
It probably is, my lord.
Yeah.
And the reason for that is what we're concerned with is the matrimonial property, as my lord has noted, is in the hands of Mr. Webb. And so when it comes to his unsecured personal debts, his creditors are able to look first and must look first to his separate property, which would not be up for division in any case. And in this case, it is common ground, or I think I can call it that there is no separate property, or certainly none that can offset a debt of some $27 million.
I see.
And
well, that's an answer then. If this is not trust property which is ignored, it's all your client's property.
Yes.
So the whole of the tax debt, if relevant,
That's
is
right.
deducted
Yes.
against it.
Yes, that's right.
Thank you so much.
So I won't trouble the board more with the nuances, if there are any, around Section 25. My lords, my lady, clearly have come to grips with that. So the next point I need to grapple with is whether the enforceability in the Cook Islands is really that much of an issue. The High Court in this case, Her Honour Justice Potter, found not. And the approach Her Honour took, which I respectfully endorse, is that, well, it is a New Zealand tax debt. Mr. Webb lives in New Zealand. The debt is going to have to be paid or compromised or dealt with in some way. Therefore, it is, on the plain wording of Section 20, an unsecured personal debt, and Section 25B makes clear what happens as a consequence.
Your first submission, as I understand it, is that subsection 5 says nothing about enforceability.
That's right, my lord, yes. I say that the enforceability issue, at which the Court of Appeal accepted, is a gloss on the section, and it requires arbitrary approach, I guess, in any given case. And the Court of Appeal had its own concerns in this case, in that it was concerned that the question of enforceability as between the Cook Islands, the Commissioner of Inland Revenue and Mr. Webb in the Cook Islands should be dealt with by what it called a sidewind in a matrimonial property proceeding. To which I say, well, that is exactly right. It shouldn't be being dealt with as a sidewind in a matrimonial property proceeding because it is an unsecured personal debt, and the section makes very clear what the consequence of that is. And the enforceability question puts the courts in a position in every case where it must look not only at the nature of the liability, does it fall within the section or not, but what could not a creditor do in that particular case. The only authority for the proposition that the enforceability issue is a live one is an relatively old New Zealand Supreme Court decision in those days, Livingston and Livingston, which does appear in the secondary bundle. I don't need to take the board to it. But in that case, the husband was Scottish. He and his wife had moved to New Zealand. First they had lived in Canada. They then moved to New Zealand, where they separated, and the husband returned to his native Scotland. He had incurred a tax liability in Canada, but he avoided that country, had no intention of returning there, and had left no assets there. His Honour Mr. Justice Summers held that, well, there's no practical likelihood or reality that this debt is ever going to be paid, therefore I'm going to disregard it. And that was the end of the reasoning in that particular decision. Her Honour Justice Potter in the High Court in this case distinguished that on the bases that I traversed a moment ago. While unlike Mr Livingston, Mr Webb is very much in New Zealand, as is his creditor, and that liability is going to be addressed and dealt with in some way. And we've talked briefly about the fact that the Inland Revenue has moved to judgment and is looking to enforce the debt. So I submit ultimately that the question of enforceability is only enforceability in a personal sense, and that whereas if Government of India, which I'll come to in a moment, which the board will no doubt be aware of, if it applies, or if it applied in the Livingston case, it would prevent the Canadian tax authorities taking proceedings against Mr Livingston in Scotland and obtaining a judgment against him. So questions of enforcing that judgment would never arise. And the distinction here, of course, is that there is a judgment. It has been obtained and is going to have to be satisfied. And if it is not satisfied, then Mr Webb will ultimately be bankrupted, presumably.
Well, there is a reference to possible bankruptcy proceedings in the 2018 judgment.
Yes, I believe there was, my Lord. So that is the ultimate outcome, and for Mr Webb. Now, like every debtor, he may well wish to avoid that consequence, but more than that, I expect very much so too would his creditor, and it would rather be paid, rather than taking its chances in a bankruptcy situation. And Section 25B says, whatever assets that might otherwise be matrimonial property that are in the hands of the debtor in question are to be made available, are available for the purposes of payment of that debt.
Can you just help, because of the cross-jurisdiction aspect of this case, we haven't got anything which defines matrimonial property. I've noted from one of the submissions that Section 7 of the New Zealand provision is to do with immovables situate abroad, which are not caught. And I'm just wondering how matrimonial property is defined. As in the New Zealand Act, it said this Act applies to immovable property that is situated in New Zealand. Read Cook Islands, presumably. I'm just wondering how this all ties in with the definition of matrimonial property, if it only applies to property in that country.
Bear in mind, my lady, this is a Cook Islands case. We're at the moment we're talking about a New Zealand debt, but it is a Cook Islands case.
I know.
So the jurisdiction will attach in that way.
But I want to know what matrimonial property is in this context, where immovable property situated abroad is excluded from the Cook Islands statute.
That is no doubt right, my lady, but just to make sure that I understand my lady's question, the immovable property, if we're talking about any, is located in the Cook Islands.
It is,
Yes,
but when we're totting up matrimonial property, I'm envisaging a situation in which the debt is secured on neither property, neither in New Zealand nor in the Cook Islands. Do we look at all at the New Zealand asset, for example, or if it's not necessarily this case, if the husband who's fighting Cook Islands litigation has got a property in New Zealand, but the debt's not secured on that, can you take that into account? And so that's what led me to want to know what the definition of matrimonial property was.
Let me...
Don't worry about it immediately, because you're in the middle of something, but in due course, that would be helpful.
I can try to deal with that now, my lady, and the best I can do is probably take the board to the Matrimonial Property Act, which a full version of which does appear in the secondary bundle of authorities.
Thank you.
It is at page 1295. It's behind tab N in the hard copy, and on my 11 pages.
Sorry.
Is it
Might
one?
it be 1278, Mr. McAnally?
Sorry, my lord, you're right. It is there are the two versions in the. Sorry, there are two
Got it.
acts in there. So it is 1278, my lord. Yes. What I was referring to was the Cook Islands Act, which adopts the Matrimonial Property Act. But so it is 1278 in the electronic version.
We're looking at in 127.
That is the Matrimonial Property Act 1976 of New Zealand.
That's the New Zealand Act.
But the version that is in the bundle, is the version that has been modified for Cook Islands purposes, if I can put it that way.
Well, can you help me? At the moment, 1278 comes under 1277, which appears to be the Cook Islands laws. At the moment, I mean, 1278 just takes me straight into section 7 and is merely headed matrimonial property, but on the previous page, this appears to be the Cook Islands version.
No.
No.
I think I can help with that, my lord.
Oh, yes.
You have a document headed Cook Islands laws.
Yes.
But this copy has been extracted from that, from the Cook Islands statutes.
Yeah.
But it is the 1976 New Zealand Act as adopted by the Cook Islands.
All right.
So we read section 7.1a and see that the act shall apply to immovables which are situated in New Zealand. And then if we want to, we can go to 1307, which is the Cook Islands adaptation. And every reference to New Zealand has got to be a reference to the Cook Islands.
Yes.
And so we've now got this act shall apply to immovables which are situated in the Cook Islands.
Yes. So that may answer my lady's question, perhaps.
No, it doesn't really
No,
define.
well-
It tells us that you've got to look at jointly held property, etc. But it doesn't tell me if you look at it still, even if it's situated in New Zealand, which was my question, really. I just want to get a flavour of the territorial ambit. No, as I say, do think about it and come back later, because it's a bit of a fast ball for...
I would like to deal with it now, my lady, if that suits, just so that we can we have it done. There is only, in terms of the property, we're only concerned with property in the Cook Islands. And, of course, the legislation applies to, the matrimonial property includes or encompasses immovable property in the Cook Islands.
What if they'd owned a house in New Zealand? Would that be caught within this?
If they did, my lord, then Section 7 may cause some problems, and my answer is I do not expect. Let me put it this way: if Mr. Webb personally owned a house in New Zealand, it would fall without the matrimonial property pool.
So you wouldn't take it into account you would take it into account in deciding whether a debt was secured or unsecured, even though it was in New Zealand?
I'm not sure you would, my lady, and I am relying on my memory somewhat, but the New Zealand cases were quite strict from memory, in that if a property was immovable abroad and fell without the matrimonial property regime, then, and I am generalising, it couldn't be taken into account for many purposes at all.
Okay.
It doesn't arise in this case because we aren't dealing with any foreign property in terms of the foreign immovables in terms of the matrimonial property pool. The only thing that is located offshore, if I can put it that way, is the tax debt.
Yes,
and that
but it's
resides in
trying
New
to
Zealand.
understand what the concept of debt is in the Cook Islands Act, because you're saying it's a real debt, but it's a foreign debt, and I'm just trying to see how foreign fits into this whole structure.
It's perhaps the best I can do, my lady, is it's an unsecured personal debt. It is personal to Mr. Webb and his place of abode, be it the Cook Islands where he did reside when part of the debt was incurred, or New Zealand, it doesn't matter, it's personal to him, and it is going to have to be paid by him, whether he be in New Zealand or the Cook Islands. So there's a distinction, I suppose, between the questions of liability for the debt and how that debt might be satisfied, but that probably takes us into the second part of this discussion, which is the enforcement issue.
Can you just help me with section 7.1b of the New Zealand Act? I'm at the top of electronic page 1278. Movables. Is your client domiciled in the Cook Islands? No, not.
No, he's domiciled in New Zealand.
Does that mean that none of his movables, does it mean that the Act applies to none of his movables? Or is the requirement that he be domiciled, leaving aside whether there's been any agreement about it, I don't think there has in this case, does the requirement that he be domiciled only apply to that bit of the first line of B that says or elsewhere? That would seem slightly
Or does it just mean that,
counterintuitive.
or does it just mean that one of the spouses has to be domiciled in, as it here is here, the Cook Islands?
Yes, my lady. Either the husband or the wife is domiciled in New Zealand.
Cook Islands. Well, we're having to change.
The Cook Islands, of course. Sorry, my lord. Yes, and Mrs. Webb remains a resident in the Cook Islands. So that probably it's a jurisdictional point, as I understand it, and there's certainly no dispute in this case that the High Court of the Cook Islands has jurisdiction in this matter.
Yes, but I'm just presumably Section 7 sheds some light on Section 20 as to what's meant by matrimonial property. I mean, that's.
We're all fumbling for the relevance of territoriality.
Yes.
And perhaps my answer, my lords, my lady, probably is that it doesn't matter. It only matters so far as, it only matters if the enforcement issue matters. And of course I say it doesn't, but we have a Cook Islands case ultimately concerning Cook Islands property. There are no personal jurisdiction issues. There is a debt which is personal to Mr. Webb, and it's really just how that interrelates to a Cook Islands matter. But
I mean, can I just give an example to show why I'm feeling a bit uncomfortable about this? Suppose he's got a property in the Cook Islands and he's got a property in New Zealand, and that because of Section 7 we're not concerned with his property in New Zealand for the purpose of identifying his matrimonial property. Now suppose the property in New Zealand is subject to a mortgage debt of hundreds of thousands of dollars, but his property in the Cook Islands is not. It would seem, at least on the face of it, slightly odd to leave out of account the value of his property in New Zealand, but to take into account the value of the debt.
the first thing, my lord, is that anomalous result, as it would appear to be, may well have been the case or be the case in that situation. And I'm just trying to think of, and I am relying on memory as I mentioned, but there are, it was certainly the case that there were situations where there was property located abroad that did not fall within the matrimonial property regime, that the other spouse could not get to, and that was ignored for all purposes. And that remained, certainly under the 1976 regime, remained quite a hard and fast position. And so the result that my Lord Briggs is talking about, it may well have resulted, but that was seen as the consequence of the exclusion of foreign immovables. Bringing it closer to home, or closer to the facts of this case, it's probably neither here nor there, in the sense that not being matrimonial property, because it's excluded from the ambit of the legislation, it wouldn't be, the debt would not be deducted from it for the purpose of division, because it would not be a part of the division, so it wouldn't bear on the matter one way or the other.
But suppose that you have property in New Zealand, facts of this case slightly amended, against which a debt is secured. Suppose you've got a secured debt, but you say you ignore immovables situated outside the Cook Islands. Do you ignore the security and say it's a debt? You can't, can you? So it can't be an absolute.
In that case, if we're talking about a security, then of course the application of the Act is different, and assuming that the debt is adequately secured, then it is not. It
doesn't matter where it's secured.
It doesn't matter where it's secured because it's not taken into account. The creditor is left with its security. There's no question of a deduction.
Okay.
So hopefully that answers my lady's question sort of adequately. So where I had got to is my submission is that there is a distinction between the facts of a case such as this, where there is a personal liability. It has crystallised in the form of a judgment debt, and it is going to have to be satisfied. And so for the purposes of Section 20 of the Act, it is an unsecured personal debt, and is to be deducted for the purposes of valuing the matrimonial property for division. The final brief point I'd make on that part before I move on to the enforceability question is that it might well be said in this case, or perhaps any case, well, even though the asset might otherwise be available to the debtor or spouse, and therefore the creditor, for the former to mortgage, sell, liquidate in some way in order to meet the debt, he might not. And in a case such as this, the creditor may be unsatisfied, because if there is an enforcement issue, then the creditor doesn't get any realisation from the asset, but the debtor or spouse retains the benefit of it. And that is a very real question, and it's not a question that lends itself to an easy answer, but the answer I do have is that, well, if we approach Section 25 on the basis that we look at each asset and decide whether or not the creditor can enforce against it, and if we decide that it can't, and we ignore the implications of Section 25, the bottom line is the debtor can't do any of those things. He can't sell it, he can't mortgage it, because in a case such as this, it has gone into the matrimonial property pool, and it has been vested in the other party to the marriage. So it doesn't matter what the debtor may or may not have done, he just can't do it. And that is contrary in my submission to the purpose of the legislation, which I of course do say and reiterate was something of a trade-off. Yes, we're going to make some good progress in terms of how we treat property when a marriage breaks down, but we're going to have this trade-off, which no longer exists so much in New Zealand, because this legislation was replaced in 2001, and a debt is either a relationship debt or it's not. But the Cook Islands has persevered, and that is a legislative decision, and I submit that whatever the implications of the application of the section might be in any given case, the section is what it says, and inquiry into enforceability issues requires a gloss on the section, which it doesn't permit.
You say this is simply a benefit which your client can take if it's not enforceable. And that's just the consequence of the statute.
Potentially, my lord, yes. That's probably the most helpful answer. But of course, it's not just a question for the debtor. It's also a question for the creditor, and how hard it might lean, what it would compromise for, and really what the alternatives are for the debtor in question. But we never know, because we're trying to gaze into a crystal ball. We know in a case such as this, we have a well-funded, experienced creditor who is pursuing a tax liability and is in the business of pursuing tax liabilities. And we have a debtor who is in the business of being in business. And there are probably implications that would rather be avoided from bankruptcy, or from having a reduced asset pool with which to satisfy the debt in question. His negotiating position might be affected. Now, I don't know if that's the case at all. Again, we're crystal ball gazing, but I come back to where I started this particular point. The important matter is that the assets are to be available. What ultimately happens is beyond the scope of the legislation and I would say the courts, because, as I say, we are crystal ball gazing. But once we get into enforceability issues, we start perhaps arbitrarily removing assets from the scope of the section, and therefore the reach of creditors, which is contrary to what the legislation contemplates.
Could you just help me a bit more with section 21A and how it works? It provides that, subject to express contrary provision, the rights of, among others, unsecured creditors of a spouse shall continue against, among other things, property owned by that spouse, as if the Act hadn't been passed. It does mean that, or it may be that an against property is only in relation to secured creditors. The right of an unsecured creditor is against a spouse's property, other than a right to go to court and get a charging order by way of enforcement, for example. And following on from that, as if this Act had not been passed, if the court makes an order for the transfer of property owned by one spouse to another, pursuant to its jurisdiction under the Act, does that cut off at the point of transfer the unsecured creditor's opportunity to enforce against that property as if the Act hadn't been passed and it still belonged to the other spouse? Or does it just operate as a bar on the court making such a transfer if it would have that consequence?
No, I'd submit, my lord, that it is that concern which perhaps underlies the section, in that if property is vested in the other spouse under the Act, then it is by definition, I suppose, beyond the reaches of the creditor, because the creditor can't enforce against property owned by a third party. And there is nothing in the legislation which specifically contemplates the idea that the other spouse might take property subject to some sort of charge or residual liability attached to it. Once it is vested, it is gone and is owned by the other spouse. And it is that consequence, in terms of the implications that has for creditors, that I submit Section 20 addresses. So that brings me to the question of enforceability, and that raises some interesting and difficult questions around the relationship between New Zealand and the Cook Islands, both as it has developed and as it is now. My starting position, of course, my lords, my lady, is that we don't have to get into this, but we have to because Mrs. Webb takes the point, and therefore I find myself having to deal with it. And the starting point in the equation, I suppose, is the House of Lords decision of the Government of India and Taylor, which I might take the board to.
Just before you do that, you submit, I think, in your case that there is no designation of the Cook Islands under the New Zealand Reciprocal Enforcement of Judgments Act.
That's right, my lord, yes.
But you say that instead there is a procedure whereby memorials can be filed and enforced.
Yes, and I will come to that, my lord. And that is found in the Cook Islands Act. So it is a procedure specific to New Zealand and the Cook Islands.
You'll come to that in...
I will, my lord, yes.
Very well, thank you.
The Government of India and Taylor is behind tab F of the primary bundle of authorities for my lords and my lady who are using that. The electronic version, adding 11, it should be at page 1070.
Yes.
And this case of the House of Lords is regarded as the locus classicus, if I can say so, in terms of the rule of exclusion that says that one state will not directly or indirectly enforce the revenue or penal laws of another. Now it's interesting and helpful, I suppose, in the sense that the House of Lords in that case couldn't quite say for sure where the rule originated and why it originated. The Lord Chancellor, Viscount Simons, observed, as did the other members of the committee in that case, that while it is a rule of long standing, it has been applied and there's no authority for it not being applied, and we're going to continue to apply it. In the opinion of Lord Keith of Avonholme in that case, his lordship had access to a decision of the courts in Ireland, and from that was able to extrapolate 3 possible and apparent justifications for the imposition of the rule. One is that the enforcement of another party's revenue laws or attempting to enforce one's revenue laws in another country was an intrusion upon the sovereignty of the latter.
Where are you reading from?
Page 511 of the report, my lord.
Thank you.
Page
So that's
1090.
1090.
Thank you, my lord. The other possible justifications for...
Sorry, can you just remind me what you got from 511?
It's the passage that my lord Keith adopts from. It's the Irish decision. I can't. And there's a quote which occupies most of page 511, my lord. So as well as the...
So tell us what's happened to this principle of law over the last 60 years.
The easy answer, my Lord, is nothing. In terms of its application between the United Kingdom and New Zealand and Australia, but for a qualification I will come to, there's no question that it would apply. It would simply be applied. And indeed, there was an occasion in the Cook Islands itself whereby the rule was applied as between the Cook Islands and the United States. The cases in the secondary bundle, I won't take the board to it. And I remember it because I think I may have written the submissions for it. The United States had imposed a pecuniary penalty under its antitrust laws against a United States citizen. That individual held funds in a Cook Islands offshore trust, and the United States wished to enforce that penalty in the Cook Islands, and the High Court of the Cook Islands concluded that the rule that we are talking about from Government of India applied.
What's the reference to that case?
It's United States of America and my Lord. It's behind tab AM of the third volume of the secondary bundle of authorities. It's page 1817, so 1828 of the electronic bundle.
Yes.
I submit that case has no application to the present because there is no relationship between the Cook Islands and the United States other than that recognised at international law. They, as between themselves, are independent, unrelated, and there is no reason in principle why the rule would not apply. The case between the Cook Islands and New Zealand is very different.
What do the textbooks say about this? And it must be dealt with in the textbooks on tax.
Not in terms of I can't help my Lord a great deal, but the rule itself, or the principle itself, is not in doubt. What makes this case difficult is what's a very unique relationship between the Cook Islands and New Zealand. There is a regime that exists only between New Zealand and the Cook Islands, as well as perhaps Niue and Tokalo, which have similar relationships with New Zealand, but we don't need to worry about those. It goes beyond. It's not the case of two unrelated, completely independent states in the sense of being fully independent of each other, because they're not. It probably transcends and goes beyond a federal union because it has many of the attributes of a federal arrangement, such as one might find in the states of Australia or the United States. But it's different to that again, so it's not overly helpful, although the idea of a federal union might be a close analogy, and Government of India doesn't really deal with that because it wasn't concerned with a federal union. And both the Lord Chancellor Viscount Simons and Lord Keith passed upon or observed that there were different arrangements between the states within the United States. Some applied the rule, some didn't. But Lord Keith in particular just didn't find the comparison with a federal union helpful. So Government of India doesn't deal with the matter.
So what principle do you say we should apply? I mean, it sounds to me as if there aren't any principles.
That, my lord, is in a way, is my submission, because it is a rule of exclusion. If this were a private debt, there would be little argument, I expect, that if it is final and conclusive, given within the jurisdiction of the court that imposed it, for argument's sake, it would be enforceable in the Cook Islands at common law. So what we're concerned with is a rule of exclusion.
The New Zealand tax authorities are presumably aware of this case, are they?
They are, my lord, yes.
I would have thought they would have rather strong views.
Yeah.
We don't know what they are.
I don't know what they are, but probably the best I can hark back to is the application for the appointment of receivers in respect of both New Zealand and Cook
There
Islands
must
assets.
be cases where New Zealand tax authorities have wanted to pursue people in the Cook Islands, or indeed vice versa.
No, my lord, not so far as the parties are aware. This case does have it has a slightly unusual genesis.
It's so odd that we're dealing with this in London. It really is ever as a case which needed to be sorted out somewhere else.
But presumably your client is in New Zealand, challenging the jurisdiction of the New Zealand courts to appoint receivers over his property in the Cook Islands.
I can't answer that, my lord, because I don't know.
You're not taking a position for this court that you will adopt a consistent position in relation to enforcement proceedings by the New Zealand tax authorities,
I don't
reserving the possibility of adopting an inconsistent position.
I don't act on the other matters, my lord, so it's hard to say what position Mr. Webb might take.
But I mean, you presumably you're being instructed by Mr. Webb, and so presumably
I am
in a position to tell us what his position is, if he were willing to tell us.
I can only assist so far as I have instructions on the point. It's not one that has directly concerned me, but I don't know. I don't know what his defence is in the other matter, because I haven't seen it. I have no instructions in relation to it. But coming back to the question, it is conceivable that he might adopt a different position, but if it is a matter which this board must address and does address and advises Her Majesty accordingly, then I suppose all concerned, including the Commissioner of Inland Revenue, will be watching with some interest.
The principle that appears to emerge from page 511, internal of the Government of India case, which is the electronic page 1090, is that the foreign state may have a policy which runs contrary to the settled public policy of the other state, where enforcement is sought.
I am going to address that, my lord, and I'm going to do that in the context of the point that my lord raised a short time ago, and that is this memorial regime. And what I'm going to come to is a submission that both New Zealand and the Cook Islands have accommodated that in the context of the Cook Islands Act and that memorial regime, and that their relationship is such that they have accepted that point and assumed, I suppose, that public policy issues do not arise. And
in other words, that public policy and notions of what is proper are the same in New Zealand and the Cook Islands. Is that your submission?
I do submit that, my lord, and I do so on the basis of the nature of the relationship, the mutual obligations and responsibilities that the parties expect and impose upon one another. And one example of that is that in the exchanges of correspondence between the Prime Ministers of the two countries, the Prime Minister of New Zealand has consistently made it clear that it is New Zealand's view that given the shared bond of citizenship, the Cook Islands are expected to maintain and uphold values that are consistent with New Zealand citizenship. So that is perhaps an answer in part to my Lord's question, because there is this commonality. We are two parts of the realm of New Zealand until we both choose not to be, and that hasn't happened yet. And
Mr. McAnally, we've obviously read the decision of the 26th November 2018, in which the district judge in Auckland gives a judgment against your client for this large sum of tax, penalties and interest. It's at 1402. And our attention, obviously, was drawn in particular to 1417, if you happen to have available to you, Mr. McAnally, paragraph 66 and 67 of his judgment. Have you got that? Have you got it?
I soon will.
Have I done the right numbering here?
Yes.
Page again?
1417.
Yes.
Because 66, if you've got that now to hand, Mr. McAnally, a reference by the district judge to the provision of documents to the Inland Revenue Department in New Zealand from the Inland Revenue Department in the Cook Islands, and a reference in 67 to sharing agreements between the two countries in reference to documents coming in at the beginning of 2012. And that did look like possible cooperation between the two states. And it might be surprising if they were cooperating about the provision of information, that they wouldn't be cooperating about the reciprocal enforcement of each other's tax judgments. But perhaps that leap can't be made.
I would dearly like to make that leap, my Lord, but I'm not sure it can.
No. There won't.
And the reason for that, I suspect, is that there is a double tax agreement between New Zealand and the Cook Islands that deals with the question of information sharing. So there is a separate regime at executive level regarding that.
Thank you.
Judge Learned Hand's explanation, which is the second explanation given by Lord Keith, appears to be saying that it's the propensity for the enforcement of a foreign tax debt to offend the public policy of the state B, let's say, where the enforcement is being sought, which gives rise to a risk that state B will invade the sovereignty of state A by ruling on that question. But provisions for which accept from mutual recognition and enforcement of judgments on the state of enforcement's public policy grounds are legion. I mean, almost every enforcement treaty one can think of has them. I just wonder how much of Judge Learned Hand's explanation really survives in the modern world. It doesn't affect the first explanation, no. But it does seem to me to be a very surprising one once you start to look at any kind of mutual enforcement regime.
It certainly appears to be the case, my Lord, that I suppose with increased globalisation and so forth, and increased international cooperation, the rule is being eroded at legislative and executive levels. And that's an interesting aspect in this case, which I was going to come to later, but I'll do it now. So the reciprocal enforcement of judgments legislation in New Zealand does, I believe, largely reflect that of the United Kingdom, and one of the and there are other various exclusions from eligibility for registration. One being revenue laws. So that still exists in terms of that wider regime in New Zealand. There is also provision in New Zealand, a different regime for the enforcement of Commonwealth judgments, which is slightly more lenient, but it obviously still includes public policy exception and does, if I recall correctly, exclude revenue laws.
Excludes them.
I believe so, my Lord.
Is
Yes,
that in the
I-
bundle?
Sorry, my Lord?
Is that in the bundle?
I believe it is. Yes, it is. It's behind tab K of the hard copy and volume 1 of the secondary bundle, page 1256 of the electronic bundle.
Yeah. Gosh. I've got the Judicature Act.
That's it, sir. Now, this is the Judicature Act was repealed a couple of years ago in New Zealand and replaced with the Senior Courts Act of 2016. This regime has not changed, and this version has been included because it corresponded with the Cook Islands Act regime, which I'm going to take the board to soon.
This has been repealed and replaced by...
The Senior Courts Act 2016 in New Zealand, my Lord. I can find you the section.
This is the 1908 Act is pre-Commonwealth, but talks about anywhere within Her Majesty's dominions.
Yes, sorry, my Lord. And
So it's a dominion regime.
yes.
Memorialisation is presumably a procedural implementation of whatever mutual enforcement there was at the dominion stage.
It's a separate regime, my Lord. It's under the Reciprocal Enforcement of Judgments Act. Enforcement under this regime was excluded. So if one was now a Commonwealth country, then one could rely on this rather than the Enforcement of Judgments Act. What I should say before leaving that section,
Which part of Section 56 do you want to take us to?
well, I don't want to take the board to any particular part of it, but I do need to come back to my Lord Kitchen's question a moment ago. Section 56 doesn't specifically expressly exclude, for example, revenue debts, but the case law around it has been held to assume that it would, in terms of, if my lords and my lady look at subsection 4 of that section.
Yes, but this is really procedural, Section 56, isn't it? And then the legal issues would all arise under subsection 4.
Yes, my lord, yes. So if the Majesty's revenue from this country were looking to enforce a tax liability in New Zealand, whilst the revenue could rely upon Section 56 or its successor, if I was the debtor, I could apply under Section 4 to the High Court and say that there is cause why registration enforcement should not follow, because this is a tax debt. And there are cases from the High Court of New Zealand which suggest that objection would have been upheld.
And sorry, which is the best example of that, or do we have it in the paper?
There is, my lord, it's a case of called Kemp and Kemp.
Vol 3AC is in.
That's right, my lord. And that's 1678 of the electronic bundle. And perhaps the most convenient thing I can do is refer my lords, my lady, to paragraph 3 of the head note to that decision, and more or less in passing, His Honour Justice Tipping observes that a foreign judgment was not generally enforceable if it related to taxes or penalties. It's not a case where the exception applied because it did not concern either of those matters, but His Honour implied that if it were the case, then the obligation to show cause might well be satisfied.
So this Kemp and Kemp would not apply in relation to New Zealand and...
I do, my lord, and at a very simplistic level I say it doesn't apply because the memorial regime between the Cook Islands and New Zealand in the Cook Islands Act of 1915 doesn't include a provision whereby the debtor in question can show cause why enforcement shouldn't follow. There's no provision for that at all. And so while enforcement, the way the memorial regime works is that one obtains one's judgment from the High Court or District Court of New Zealand or of the High Court of the Cook Islands, as the case might be, and one applies to have that registered in the other court. And upon once that has been done, execution may issue with the leave of the court in question.
But if the leave of the court is required for execution, doesn't that open a window in which issues of this matter?
It does, my lord. It does open the window. It does open the window, but I say that window soon slams shut for two reasons. One is that leave can be applied for ex parte, so there's not necessarily any consideration at all. More than that, the section has been seen, the leave provision has been seen as something of a gateway. There are not many cases where the section has been examined or explored by the court. One is where a Cook Islands company was looking to enforce a judgment in New Zealand, and it wished to apply for a charging order over property owned by the debtor. The High Court was satisfied that the property was owned by the debtor, and leave was therefore given. So that the question was whether the enforcement process that the creditor wished to adopt was appropriate and available, not whether enforcement should follow at all. And that case suggested that it's not really a question. The court doesn't have a jurisdiction to decide whether there should be partial or necessarily no execution, but it's a residual discretion, I suppose, if I can put it that way. And I'll give you the reference to that, the case I'm talking about.
Come back to it after the short adjournment, please, Mr. McAnally.
Thank you, my lord. I'll do that. In similar vein as a case somewhat closer to home, and it's Webb and Webb, which is a 2018. I'll call it a decision. It's more of a minute from the High Court, and that's behind tab AO of the third volume of the secondary bundle, and that's page 1860. And in that case, the Mrs. Webb with whom we're concerned here and Mr. Webb are involved.
187, though, it might be.
Sorry, 1870.
Yeah.
Yes.
Yes.
In that brief minute, Her Honour Justice Fitzgerald described the provision, the leave requirement, as something of a gateway to enforcement, and that is consistent with the notion that it's not really a question as to whether enforcement should follow, it's more a question of whether the method of enforcement is available and appropriate.
Can you explain what was going on here? We've read that page. We see that the wife was taking proceedings in New Zealand, and we read that possibly she got her order on, I'm looking at the last line, Friday the 12th of October. What was it all about?
Maintenance.
Maintenance, very well.
So that was the enforcement of a Cook Islands maintenance order in New Zealand.
That's right, my lord, yes.
I don't know whether is this ex parte or is this inter partes? No appearance for the respondent, but I don't know whether the respondent was summoned.
He was given notice, my lord, so it's not ex parte in the true sense.
So it's an inter partes application.
Yes. It didn't have to be, I should add, given the legislation, but he did receive notice. Whether or not it was ex parte application or not, procedurally, I can't remember. The interesting thing about the legislation, I'll deal with it in a little more detail now from a historical point of view. The sections we're concerned with which are sections 142 and 173 of the Cook Islands Act. They're behind tab C of the primary bundle of authorities, page 1018 of the electronic bundle. Predate.
Section 142 of the Cook Islands Act 1915.
That's right, my lord, yes. Now those sections and this procedure predate the enactment of the Cook Islands Constitution and its acquisition and adoption of self-government. So they have been left intact despite a number of significant other legislative changes. So in 1965, when the Cook Islands Constitution Act was passed, the Cook Islands became self-governing, as it still is. But there were, in particular then, and for the next 15, 25 years, and still very close links to New Zealand. As the written case elaborates upon, the head of state remains the Queen and right of New Zealand, and the countries have described themselves as two parts of the realm of New Zealand. Citizenship has throughout been shared, and of course New Zealand maintains the ultimate statutory responsibility for the Cook Islands foreign affairs and defence. And those matters traversed in the case, in my submission, dilute the rationale for the application of the Government of India rule on the grounds of sovereignty. The sovereignty is effectively shared, and whilst the Cook Islands does have its own parliament, its own ministers and its own courts, they are the consequences of a incremental legislative development, which are steps towards full independence, but those steps have not yet been completed. Now, there's nothing paternalistic or colonial about any of that, because the Cook Islands is at liberty to make those steps as quickly and when and however it likes. But that doesn't change the fact that for present purposes both countries choose to share the same head of state and choose to share mutual obligations touched upon earlier, not only the matters of foreign affairs and defence, even though those matters are undertaken at executive level in collaboration and in many respects as an agent for the Cook Islands, those responsibilities remain, and there are the shared bonds of citizenship which carry with it certain mutual obligations.
There's presumably complete fiscal independence. In other
Yes,
words,
yes, my lord, yes.
each place makes its own revenue laws.
Yes.
And raises such revenue as it needs for its budget.
That's certainly
Subject
the
to the
case,
point
yes.
about shared defence.
Yes, that's undoubtedly the case. I like to think of, whereas I think of the old dominions such as New Zealand as Australia as the child who has grown up and left home and moved abroad or what have you, and sends mum and dad an email or a text now and then, with the Cook Islands has very much grown up. There's no question about that, but they still like to go home for a nice meal occasionally and to have the laundry done. and that's
Certainly ask for money.
they choose. The relationship remains a close one. The nest
That's sufficiently different for you to have to come here to get a final decision on this case.
that's they certainly have. It's an interesting point, my lord, and they have parted company from even at a judicial level, as one would expect. But that has been incremental, and that brings me back to the sections we're talking about. In 1965, when the Constitution was enacted and self-government was achieved, there was a High Court of the Cook Islands, but at the same time, the appeals from that court were to the High Court of New Zealand, as it is now called, and the High Court of New Zealand had jurisdiction in respect of Cook Islands matters. And that remained the case, the jurisdiction remained the case until 1969. The right of appeal remained the case until 1980, at which point the Cook Islands, legislating for itself as it does, abolished that jurisdiction and enacted provisions for its own Court of Appeal and for appeals from the Court of Appeal to this board, to Her Majesty and Council. Now, whilst all of those changes were going on, these sections we're concerned with, section 142 and 173, weren't changed. There have been inconsequential amendments to reflect that the change to the names of the New Zealand courts. The Supreme Court of New Zealand became the High Court of New Zealand in 1980, and the Magistrates Court became the District Court in 1980. But otherwise, these sections have remained unchanged. And this is while the Cook Islands are going through the very process of considering the judicial relationship between the two companies. Sorry, the two companies, I should say. And this regime remains unchanged. Now, if we hark back to that period between 1965 and 1969, when the High Court of New Zealand had jurisdiction in respect of Cook Islands matters, it would have been quite practical and possible for the Inland Revenue, for example, to bring proceedings against a New Zealand citizen resident and owning property in the Cook Islands and obtain judgment in the High Court of New Zealand for that tax debt. And in my submission, it would be inconceivable that judgment, given by a court with jurisdiction in Cook Islands matters, couldn't then be enforced in the Cook Islands. And I don't expect anyone would seriously contend that would be the case. And all that would happen is that the memorial regime in section 173 of the Cook Islands Act would be looked to. The sealed judgment of the High Court would be registered and enforcement would follow with the leave of the High Court of the Cook Islands. And the High Court of the Cook Islands would not, in my submission, in a case such as that, look to questions of public policy or the nature of the debt, because that would be silly in my submission. Why would the High Court of the Cook Islands be second-guessing the jurisdiction of the High Court of New Zealand, which the Cook Islands Act at that time gave it? And that, in my submission, informs very clearly the nature of the process, which is we have a very open relationship and we will enforce each other's judgments quickly, conveniently, and that is part of being part of the same family in terms of the realm of New Zealand, if I can call it that. And if, in my submission, it was intended that after the High Court of New Zealand lost jurisdiction in the Cook Islands, when other changes to the Cook Islands judicial landscape were being made, if a rule of exclusion were to apply to this unique relationship, then the Parliament of the Cook Islands, and New Zealand for that matter, because it cuts both ways, would have legislated accordingly. And they haven't. It might be possible to say that the Cook Islands would take that, the fact that the New Zealand revenue might enforce liabilities to it in the Cook Islands, it might accept that as part of that shared bond of citizenship, that unique relationship of partnership and free association. And there's no reason why New Zealand would not take that on the chin as well. It has certainly offered a regime and entered into an arrangement with Australia, whereby there is no impediment to the enforcement of Australian tax debts in New Zealand, and that is under the Trans-Tasman Proceedings Act of 2010.
Reference?
It's not in the bundle,
Very well.
my lord.
What's the name of the act?
It's the Trans-Tasman Proceedings Act.
Trans-Tasman
Proceedings Act 2010. I do have copies of the relevant provisions if it would assist. I raise it more or less in response to a submission I noticed in Mrs. Webb's case, where it was observed that there's this double tax arrangement between New Zealand and the Cook Islands regarding the sharing of information. And the argument I took it to be was that, well, there's nothing that just indicates that there's just a typical arrangement and a relationship between the Cook Islands and New Zealand as any other country, because there is a similar double tax agreement between New Zealand and Australia. And my response to that, as just articulated, is, well, that's definitely the case. There isn't this proximate relationship of partnership and free association between New Zealand and Australia, but Australia can enforce its revenue laws in New Zealand.
I think we would like a copy of the relevant section of that Act. If you've got 5 copies now, fine. If you haven't, then at 2 o'clock, please, Mr. McAnally.
I do have them, my lord. I'll hand them to Mr. Registrar now.
Mr. Hikaka, have you got this?
No, he hasn't, my lord.
No, my lord.
Thank you.
Thank you.
If my lords and my lady would just note section 68, and that is the relevant provision of that Act. The preceding sections deal with what is and what isn't a qualifying judgment for registration in New Zealand.
Here he is.
So the point I wish to extract from that is that whilst New Zealand might be, and I say might be considered the senior partner in this relationship, and why would it countenance for one moment the enforcement of Cook Islands revenue laws within New Zealand, my answer is, well, why not? It offers a similar privilege, if you like, to its close cousin, Australia, but there's no question that the relationship between New Zealand and Australia is far more distant, at least from a constitutional and legal point of view, than that between the New Zealand and the Cook Islands, which is essentially a relationship governed by legislation in terms of how it develops.
Now, where are we going, Mr. McAnally? What's next?
Well, I'm conscious, my Lord, that there is a no less vexed topic, which is that of the trusts. So what I might quickly do is flick through my notes, if you'll indulge me, and...
Well, you're obviously right to appreciate that it may be that the debt point is, or the debt point on any view is very important. And so if there's anything more you want to say about that at this stage, then you really must do so.
No, thank you, my Lord. That's...
I just pick up one point. The paragraph 32 of the Court of Appeal's judgment refers to a number of authorities on the tax, foreign tax principle, as they call it, and shows how it's applied in different situations. I don't think we've got any of those authorities, have we? I mean, I take it, therefore, they probably don't help, or do they?
No, we don't have them, my Lord, and my submission is that they don't help, because whilst they are examples of the rule being applied, it's been applied in traditional or orthodox situations, unlike this unique relationship we have.
So they simply confirm it as a general principle, but don't help on the issue of construction.
That's right, my Lord, yes.
All right. Thank you.
So I'm going to march on to the trust issue, which has a number of facets to it and that are not easy to necessarily corral and address in a coherent way, but I'm going to do my best. There is a preliminary point I need to raise, and that is in relation to the new point that appears in Mrs. Webb's written case, and in respect of which a grant of leave has been given to raise that new point. And it is the perpetuities point.
Leave has been granted, has it?
Yes, it was granted by consent, my Lord.
And consent?
Yes.
Leave has been granted by the board for this point to be taken?
Yes. There was no opposition, so the registrar made the order, my Lord.
I see.
But there is a complication. The point taken, and I say in respect of which leave was given, is that the trusts are void for perpetuity because in Mrs. Webb's submission, the vesting provisions in the trust deeds did not provide for the shares of the final beneficiaries at the vesting date. That is the basis upon which I say leave was consented to and given, and I've addressed that matter in written submissions, which hopefully my lords and my lady have, and I'm not going to take you through those because they deal with that point adequately, I hope. What I understand that Mrs. Webb does want to do now is submit that not only is there that issue, but the Webb Family Trust, which provides for a vesting date 60 years from the date of settlement, is also bad for perpetuity. I haven't addressed that point because the written case was quite clear that it was not being taken. I, in fact, and as my written submissions will make apparent, overlooked the distinction between the two dates. In the Ararangi Trust, the vesting date is 21 years hence.
Is this new point in Mrs. Webb's case?
No.
So you've been alerted to it by a letter or orally from your learned friend?
My learned friend emailed me whilst I was sitting in transit in Dubai, my lord. And whilst I'm pleased to say there's been a great deal of cooperation in this case at a procedural level at all stages, this is one point on which I cannot cooperate, I'm sorry, because I just cannot help the board on it. I've not had time to address the point.
Well, ignore it for the moment, and we'll hear Mr. Hikaka on whether he can secure our leave for the extra dimension of the point on which you say he's been granted leave. So put it to one side, if you'll be so kind.
Yes, thank you, my lord. That's helpful.
The permission which you say has been granted on the other point, that's not in our papers, is it?
The grant of leave.
On the other
I
point.
wasn't aware of it.
No, it was issued by the registrar, my lord. There was an application made. It's not in the bundle.
Well, don't worry now, but a person... I would like
You did say in your case you opposed leave, so why were you consenting to it?
No,
It doesn't matter, Mr. McAnally.
I think perhaps over the shorter journey it would be nice to clarify, because I think it's news to us.
It isn't.
let me put it this way, my lords. This might help. The point in respect of which leave has been given, it was granted by consent, and a minute was issued by the registrar, deals with the identification of the shares at vesting date. So the point as it appears in Mrs. Webb's written case from paragraph 110 is the subject of a grant of leave, and it is the subject has been dealt with in my additional written submissions. So there's no issue around that. What I am concerned with and I'm raising is an argument that the...
Well, there may be concern from us, what I'm saying, so let's leave it for the moment, because for my part, the idea that we should suddenly be asked to decide a point of Cook Island perpetuity law without any reference from the local courts does cause me concern, but there we are.
I mean, not even in the case. So Mr. Hikaka may have a problem this afternoon, but let's see how things go.
Thank you, my lord. Now, the trust, the arguments regarding trust raise difficult issues, and much criticism, of course, is made of Mr. Webb's management of the trusts, of Mr. Webb generally. Some of it may well be warranted, some of it may not. It doesn't matter in my submission. And the argument seems, in some ways, seems to move to an argument in support of some notion of an objective trust, whereby the trust deeds include provisions which are such that the parties that included these terms in their trust deeds can't, from an objective point of view, have intended to create a trust. I will come to that in more detail, but in my submission, that proposition, if that is a correct enunciation of it, goes far beyond any authority at this point. Probably the closest is the decision of the High Court of England and Wales in the Pugachev case, which is the only party I can actually pronounce, and that's the decision of Mr. Justice Burse of 2016. I'll come to that. But the basic starting point in terms of my approach to the trust questions is that they're either trusts or they're not. The terms of the deeds in question are either sufficient to create trusts or they're not. And of course I'll be arguing that they are. And irrespective of the terms of those deeds, there's either a sham or there isn't. There's no middle ground. One doesn't have an objective sham. And I am going to deal with the question of sham first. It can be dealt with in any order, but sham is probably a good place for me to start. And my starting point is it's a serious allegation. It's essentially an allegation of fraud, and not one to be made lightly, which, of course, countenances any objective notion of a sham. One cannot objectively be fraudulent. And the main difference between the parties, at least from a legal point of view, is I submit, of course, with respect that Her Honour Justice Potter approached the question of sham in a fully orthodox and appropriate manner, and the Court of Appeal, having decided the matter on other grounds, of course, didn't interfere with any of Her Honour's findings, but satisfied itself to say that given Her Honour's factual findings, then there is no sham.
I wonder whether you're setting up a bit of an Aunt Sally and therefore relishing the prospect of knocking her down. I mean, isn't the crucial inquiry the Clayton inquiry, where there are a bundle of powers and rights given to your client under these trusts, which make the assets of them property for our purposes?
Yes, in my submission it is, my Lord. That's the sham. I feel compelled to address it because it remains a live issue in terms of Mrs. Webb's position, but I don't want to dwell on it because time is precious. All I perhaps need to say in terms of the approach is the difference between the parties seems to be that Mrs. Webb seems to contend that the inquiry, as far as this sham allegation goes, is whether or not Mr. Webb intended to assume the fiduciary obligations of trusteeship. In my submission, that is not the proper inquiry because that requires an investigation into a party's legal knowledge and the party's knowledge of the fiduciary obligations that arise. The question on a sham allegation is far more straightforward in a sense, in that a document is a sham if the parties do not intend to create the rights and assume the obligations that the document in question says they assume. They intend to create and assume a pretense, but the pretense is not in the implications of the assumption of those rights and obligations, but it's whether or not the document is to be regarded by the parties as binding. And that is the question which, in my submission, Justice Potter rightly asked herself. She uses words such as, did Mr. Webb intend to create a trust? But that is a sensible way of paraphrasing the question, because Mr. Webb, as settlor of both settlor and trustee of the Ararangi Trust, and as trustee, but not settlor of the Webb Family Trust, has purported to create and enter into trust deeds. So there is nothing particularly magical about the terminology that Justice Potter has used. She has asked the right question: are these documents pretenses or are they not? And then she has proceeded to look at the evidence and decided that the evidence does not establish that Mr. Webb intended these documents to be pretenses or shams or whatever. I'd leave that point by observing that the cases make it clear that ignorance of one's legal obligations is not of itself evidence of sham. In the New Zealand cases such as Vervoort and Clayton, which are referred to in the written cases, trustees have been guilty of poor management. They have displayed ignorance of their fiduciary obligations and relied upon advisors, but that was not taken to be evidence that they did not intend to create the rights and obligations and relationships that the documents purported to create. And it's telling here, because we are concerned exclusively with allegations of subsequent conduct that prove that the documents were shams when they were made, which of course, as I'm sure the board is well aware, is the point of inquiry. Something can't subsequently become a sham. It's either a sham at inception or it's not.
I'm a bit puzzled about the concept of a sham. If a document actually does create a trust, but the person intended that it shouldn't, the sham intention, then it's still a trust, isn't it? So does it not turn on whether the document's effective or not?
Yes, my lady. I would say that is largely right. The law does recognise the concept of sham, but within that framework of fraud, it's where one is creating documents to conceal the actuality, I suppose. So if one has created a trust deed, as is the case here, and then has proceeded, even if poorly from a perhaps a management point of view, to adhere to those documents, then it would be very difficult in my submission to make out an allegation of sham, because it is regarded as quite an extreme finding, not only because of the fraudulent connotations involved, but also because in the context of a trust, there are usually going to be third-party beneficiaries who are affected, who have acquired rights or appear to have acquired rights under the trust, and all of a sudden those rights are divested. So there must be very clear evidence of essentially fraud in my submission to justify a finding of sham, and that is more or less the approach that the High Court took in this case. Right, Justice Potter did record various aspects of Mr. Webb's trust management that was less than satisfactory. Cavalier was Her Honour's word in one context, but that doesn't mean that the documents themselves were pretences or shams. So there's a difference, of course, between actions might be in breach of trust, but that doesn't mean there was no intention to create the trust.
Yes, well, why don't you move on to other aspects of this issue?
So I'm going to move on. I'm conscious that the break is coming quickly upon us, so I'm going to move on to what I will call the alienation point, and this is...
We would usually continue until 1, unless it was really inconvenient for you.
It's not inconvenient, my lord. No, I'll march on until
let's press on until 1.
And this is the essential point that my Lord Wilson alluded to earlier on, and that is there are two aspects to it. One is, are the terms of the trust deed sufficient to create trusts? And secondly, are there powers reserved to Mr. Webb as settlor in the case of the Ararangi Trust that have consequences either in terms of being property or, and I suggest this would be a difficult conclusion to reach, that in some way invalidate the trust themselves. And there is this murky middle ground that finds a little support in the Pugachev decision, which I think Mrs. Webb is looking to take to some new levels, and that is that the terms of the trust themselves, even though on their face they create a trust, might themselves evidence a lack of objective intention to create a trust. I won't really deal with that, or not very much anyway, because in my submission it doesn't. I may well have misunderstood what Mrs. Webb's argument is going to be, and if I'm close to what it actually is, then I submit that takes Pugachev to, as I say, to new levels and is bereft of authority.
I'm speaking entirely for myself. I think that the sooner we go to the trust, the earlier trust, and then if you want the later one, and look at the terms and see whether your client has so much control given to him under the terms in relation to the assets of the trust that if one's being sensible, or in the phrase used in one of the English and Welsh cases, Charman, that was approved in Clayton, bringing a sense of worldly realism to the matter, we must call that bundle of rights and powers property of your client. If you don't mind my summarising what I see to be the central issue here.
It's very helpful, my lord. Let me do that, and what I will do, given the time we have available, is I will take your lordships and my lady to clause 14, which and address that quickly before the break, because this clause 14 was the touchstone, if you like, of the Court of Appeal's decision. The Court of Appeal took this clause 14 as the evil which enabled all others to be committed.
Now we're talking about the Ararangi Trust, are we?
The clause is common to both, my lord, but essentially we are talking about the Ararangi Trust because there are
it's in various places, but in principle it's at 837, add 11 to that, 848. Clause 14 is
clause
at
14.
852. Yes.
The Court of Appeal effectively, well, perhaps did regard clause 14 as negating any conflict of interest, and therefore doing so negating the trustees' obligations to comply with their fiduciary duties. That it is largely a matter of interpretation. In the written case, I have hopefully not wastingly traversed some of the authorities regarding interpretation, really just to make the point that when we are looking at trust deeds, we apply much the same analysis that we would if we were looking at any other deed or contract. In my submission, the proper interpretation of this clause is not that which tears the house of cards down. The interpretation which the Court of Appeal has favoured, in its view, enables the destruction and invalidation of the trusts. And that, in my submission, is an extreme interpretation and inconsistent with the context and the fact that these documents are designed to, and in the absence of a sham, intended to create trusts. In my submission, clause 14 is designed to enable commercial transactions with third parties that a trustee might in some way be related, which of course in the ordinary run of things could cause trustees problems because a potential conflict is as good as any conflict and should be avoided. But the clause does enable the trustees, for example, to deal with another company or another trust if it is in the interests of this trust to do so.
I mean, we've jumped to 14. Of course, at 2:849, we remind ourselves that the beneficiaries were your client and his son. And if we go to 856, the schedule, and number 11, until the date for distribution, the trustee to pay, apply, or appropriate the whole or any portion of the capital or income of the trust as the trustee shall in its controlled discretion think fit. And your client was the trustee. Equally, belt and braces perhaps, clause 18 at 854, The trustee may at any time during the trust period, with the prior written consent of the consultant, if any, vary the provisions of the deed. So it is 1 o'clock, so after the short adjournment, would you like to try to persuade us why your client did not have total control
I would
over
urge-
the assets of the Ararangi
I
Trust?
would like to try to do so, my lords. That's convenient. Thank you.
Thank you very much.